Bench will have heard his comments. We now come to the backbench motion on the government response to the Sir Aymas Morse review of the loan charge 2019. Mr David Davis to move.
I stand to move the motion in the name of Ruth Cadbury, Dr Julian Lewis and myself, and supported by some 40 other members of this House. And I start with commending my right honourable friend for having the cunning to beat me to the punch in this particular debate. It may seem strange to outside observers that in the midst of a global pandemic and a huge national crisis that we are talking about a tax technicality, or at least that is how it might appear. But actually, it's one of the great virtues of our country that no matter what the crisis, whether it's a pandemic or whether it's warfare, this House always pays attention to issues of natural justice. And we never ignore issues of natural justice, even in times of crisis. And as a matter of justice, which this is not a party political issue. In politics, in our business, justice is a matter of honour that we deliver to the British people, and that's what we intend to do today. And this is an injustice with very large consequences. We have all met and listened to constituents who are facing utter financial ruin as a result of this policy. It is ruining people's lives. There have been at least 7 suicides caused by the stress, the anxiety and the financial hardship of this policy. And here is to give the House the flavour of this, because it doesn't just apply to those who commit suicide, but those who are under the stress. Here is what the family of one loan charge victim told the all-party group about his suicide note. Quote, "He wrote about being at the end of his tether with a loan charge. He wrote such awful things about himself, things that just weren't true, that he clearly thought about himself at the time. He wrote he did not set out to do such wrongdoings. He wrote about being unable to speak to his GP about his anxiety as he was ashamed, his fear of going to prison, his disgust at himself for getting mixed up in the loan charge, and his belief that he would now go to hell." In the case of this individual, the loan charge policy did not just take his money, it took his self-respect and eventually his life. And there could be more. According to the loan charge all-party group, 39% of those affected have had suicidal thoughts. I think the Minister will be hard-pushed to think of another government policy that's caused more than a third of those affected to consider suicide. But it's no surprise it's having that effect on people. 68% have suffered depression, 71% faced bankruptcy, 49% could lose their homes. And I've said in the previous debate on this issue that the power to tax is the power to destroy, and that's never been more clearly demonstrated than here. I will give way.
Grateful to the right honourable gentleman for giving way, and congratulations on winning this debate. On the all-party parliamentary group, we took evidence from a number of family members of people who had committed suicide as a result of the loan charge. And can I underline the point he is making? The impact on people who had been law-abiding, hard-working throughout their lives has been quite traumatic. And in some cases, a particular case that I remember, I'm sure my honourable friend from Brentford and Isleworth will remember, the person who took his own life did not owe a huge amount of money. It was the fact that he had been made to feel like a criminal when he was anything but.
The right honourable gentleman makes an extraordinarily powerful point in his own skillful way. And I say but this back to him. His committee took this evidence before the added economic stress of the coronavirus. Because many of these individuals will be contractors. There'll be people who maybe have no rights at the moment and certainly no way of finding the money to meet the demands upon them. So even small sums of money will bring enormous pressure to bear on the individual. So he's right, this is not some vague and abstract tax issue. This is about people's lives. And that's why I was pleased when the government launched the Aymas Morse review into the policy. And in December, Sir Aymas Morse published a detailed report, and I commend him, frankly, for his heroic attempt to find a compromise, because that's really what he did. The facts and the conclusions are a little different, and the reason is he was trying to find a compromise. But I'm afraid when it comes to matters of natural justice, a compromise is nowhere near enough. Such a detailed review deserves detailed scrutiny, and within the limits of the time, I'm going to spend a small amount of time looking at his central findings. Now, Sir Aymas recommended a December 2010 cut-off date for the loan charge. All loans before that date will be out of the loan charge scope. Now, in a piece for the House magazine some time ago, I referred to that as arbitrary, and Sir Aymas responded. He said it's not an arbitrary date, it's the date from which the Finance Act 2011 ensured a tax was charged on income paid through loan schemes. Well, that simply didn't make sense even in its own terms. The Finance Act was not law in December 2010, it was simply draft legislation. It was not passed for another 8 months until July 2011. Now, HMRC does not, or certainly should not, take its instruction from draft legislation. It certainly should not take it from press releases, which was what actually went out on that day. It takes its instruction from settled law. And both of those words matter. Settled law. Sir Aymas went on to argue in his House magazine piece that once the 2011 Act was passed, tax should have been understood as being due from that point. But even in 2011, the law was far from clear, after the government suffered a series of defeats in the courts.
Am I right, Honourable Friend, give way on that point?
I will give way, yes.
Thank you, Mr Deputy Speaker. My constituents just don't have any extra money. They've used it all up each year. And frankly, after 2010, they were continually told by financial experts and the companies they were contracted to that all was well, carry on. So suddenly, in 2017, they're faced with a massive bill and they just can't cope.
And what I'm talking about now is how we got that position. He's exactly right, and I'll talk again about the financial status of the people we're talking about today, but and he's right, they aren't rich people, again I'll come back to. But HMRC, who have claimed that this is clear law, lost the case in Dexter and Sempra cases in 2002 and 2008 respectively, when the court specifically rejected the idea that the loans could be subject to income tax. HMRC then lost a case first in 2012 and then again in 2014, demonstrating that the 2011 legislation had not clarified the law to the satisfaction of the courts. And that's a key point, not to our satisfaction, not to our constituents, to the satisfaction of the courts. Now, the fact that HMRC lost twice and then won twice tells us that even experienced, highly informed judges spending a great deal of time studying these cases found it a difficult issue to resolve. I will allow him on that point.
Isn't the proof of the pudding in the fact that the 2017 legislation was introduced? The loan charge itself is a standing proof that previous legislation was not sufficient to tax these people. Otherwise, they'd have done it.
As usual, my right honourable friend trumps my argument in advance, but I will come back to it in a second. You see, what that demonstrates, and his point demonstrates too, is the failure of the Treasury and HMRC to write clear and comprehensible legislation. So, if the judges can't understand it, what chance ordinary laymen, people who cannot afford to employ an accountant? And we're not talking about city slickers here or international bankers. We're talking about locum nurses, social workers, care workers and hospital cleaners. I give away the
I'm grateful to the right honourable gentleman and his point that these are not just all city slickers, tax avoiding, money grabbing sorts. Reminds me of my constituent, Caroline Cheesty. She was a social worker in the public sector, 24 years experience with local authorities, had a career break, then when she wanted to go back as a locum, was advised either you form a PLC or you go with an umbrella company. That's what she did. She came to my surgery in tears. Does he not agree with me that the government should go after the promoters of these schemes, not the little people?
She's tempting me into a political point because the Blair government was the most active promoter of these things, but she's right in general. The point is right in general. Now, 1 second, I'll make 2 paragraphs progress, and I'll give the my honourable friend his intervention. Now, when something is as unclear as this tax law obviously was, you don't take the date of resolution from the first date that HMRC wins. You don't say, we keep going until they get the answer the government wants. You take it from the day it's resolved finally in the Supreme Court. And the case was not finally and definitively settled by the Supreme Court until 2017, where it found in HMRC's favour on Rangers and Dextra and the Sempra cases. Now, the government, again, and this is my right honourable friend's point, then passed further legislation to clarify the law. Even after the court case, they then passed the legislation to clarify the law. So if it was so clear, his point, why do we need a new law in 2017? That's the fundamental centre of this. I give way to my honourable friend.
My right honourable friend is making an unanswerable case in logic, but I would just like to make another political point and put it to him, and that is the cause of tax avoidance is not normally associated with such parties as the Labour Party or the Liberal Democrat Party, but I'm sure he would acknowledge that honourable and right honourable members from both those parties have played a leading role in trying to put this injustice right.
He is absolutely right. I started by saying this was not a political issue, it was an issue of honour. And as you would expect from our House, one of the greatest parliaments in the world, if not the greatest, all sides take part in defending that honour. And on that point, I give way to the right honourable gentleman.
In giving way, the intervention was spot on. This has brought the House together, because the issue isn't about tax avoidance. I think everyone on all sides disagrees that tax avoidance should be clamped down on, and there's no disagreement that the loan charge could apply in the future. What has concerned many of us very deeply is that this is offence against the rule of law, which is supposed to be a basic British tradition, one of our core values taught in our schools. And so I do totally agree with the points made by the right honourable gentleman.
I nearly called him my right honourable friend from my days in the Public Accounts Committee, but the right honourable gentleman. So, when financial advisors and accountants could not understand the law, when employers could not understand the law, when the courts could not agree on the law until 2017, how could an ordinary layperson possibly have understood the law? Now, the Supreme Court's eventual decision, overturning 3 decisions before, reflects changing national attitudes on the responsibility of the taxpayer. The point that the right honourable gentleman has just spoken really lights on. One second, I'll just finish the paragraph and then I will, of course, give way. As a result, one professional organisation, one organisation representing the professions involved here, explicitly changed its own guidance to its members. And what it said was, members must not create, encourage or promote tax planning arrangements or structures that set out to achieve results that are contrary to the clear intention of Parliament in enacting relevant legislation and or are highly artificial or highly contrived and seek to exploit shortcomings within the relevant legislation. In what year was that changed guidance handed out by the professions? 2017. I give way to mine.
I'm very grateful. He's making some very good points, which I agree with. But does he not agree that if something looks too good to be true, it usually is? In my business, we have been brought these kind of schemes over the last 30 years a number of times by our advisors, maybe with a barrister's letter to say, don't worry, it'll all be fine, but you can reduce your tax bill hugely by adopting this scheme. We always rejected them because we knew the risk was there. There is a requirement, does he not agree? There's a requirement on the individual who subscribes to one of these schemes to make sure they understand the risks, and there is no guarantee that these schemes will actually ultimately reduce their tax burden.
Firstly, I'd say to my honourable friend that, of course, he is a skilled businessman and he knows what he's doing and he's across this, and it's his job to be across this sort of thing. If you can say that about a locum nurse, or a social worker, I am not so sure. But this was actually at core, the centre of Sir Aymas Morse's arguments, which I will come to, I think, immediately. Actually, I may as well. Sir Aymas took the view that the attitude from 2017 should apply right back to 1990, back to 2010, even though the law in effect not being clear. And what he said was, I take the view that the principle of a taxpayer's responsibility for their own tax affairs must be upheld. That's the point, I think, that my honourable friend is making precisely. Well, that's true. That's true. But only when the law is clear. Only when the law is clear. Which means the government itself has a responsibility. It has a responsibility to make the law clear and not to punish ordinary, hard-working taxpayers when it fails to live up to that responsibility. And HMRC themselves seem to disagree on the importance of the taxpayer's own responsibility. Why do I say that? Because until 2014, HMRC didn't approach the individual taxpayers. They approached the advisors. They approached the companies that insisted, and I note, insisted, didn't ask, insisted with their locums and their social work, insisted that they took up this option. That's what HMRC did. They went to the advisors until 2014, until this suddenly started to become quite controversial. And last year, the Prime Minister himself commented on this. He said, the real culprits in this matter, if I may say so, are perhaps not so much the individuals themselves who've decided to use the loan charge as a way of minimising the tax exposure, it's the people who advised them that it was a sensible thing to do. In my view, we should find a way of going after them. That's the Prime Minister's view. And I happen to agree, unusually. Would you forgive me? I really do. I've tried to constrain this to 15 minutes, and it's beginning to be a struggle with so many interventions, so if you'll forgive me. So in summary, these people are now suffering because of a history of poorly drafted regulation and legislation and poor management by HMRC targeted on the wrong people. Now, on many occasions, the Minister and his predecessor have told me and this House that the loan charge is not retrospective. In his report, Sir Aymas Morse says the loan charge can look back 20 years. This design has been described by the Treasury as retroactive. The report describes the loan charge throughout as backward-looking. HMRC have denied it's retrospective. They said it's retroactive. Well, if I may say so, that's a distinction without a difference. Yeah. When I looked up retrospective in the thesaurus, guess what it said? It defined the word as retroactive or backward-looking. So, not only that.
Maybe the thesaurus wasn't clear.
Yes, I'll send HMRC a copy of Microsoft's thesaurus. But not only that, in paragraph 3.8 of his report, Sir Aymas says the review's legal advisors found that there was no precedent for that element of the design. That's the retroactive or retrospective or looking back element. There was no legal precedent for this design. So I hope the government, frankly, will now stop playing with words and finally concede that this is indeed a retrospective measure, an unprecedented retrospective measure. And so the only just, fair and rational resolution is to remove the retrospective nature of the loan charge and set the cut-off date when the law became clear. Yeah. When the Supreme Court finally settled the matter in 2017 and when the government felt it necessary to legislate to make it clear what it meant in the first place. That's why, and as I made clear before, if the government does not act to address this, Parliament, all of us who take this very seriously, will have to act for it and make clear that in future HMRC can under no circumstances act retrospectively. So here comes a finance bill if we can't solve this. Now, I would suggest one very simple adjustment to his plans before they are published, to change December 2010 to July 2017. That would resolve the issue. It would lift enormous pressure off our constituents, 50,000 of them, and it will put the government in a morally defensible, justifiable and decent position. Tax law is the only part of English law where innocent until proven guilty does not apply. If the HMRC tell you you owe money, then until you prove otherwise, you owe the money. So it's very, very important that the law is clear, that it's not subject to reinterpretation by subsequent governments, that it doesn't move with social mores or whatever. It is simply clear. And that's what we have to do. So in the interest of natural justice and the interest of the financial and mental well-being of thousands of our constituents, it's time for the government to change its mind and remove this harrowing burden from the 50,000 people who've been caught by it.